This version of employment law focuses on common mistakes made in employment contracts for workers in Manitoba working in individual employment situations, presented by Kara Bashutsky. There's no requirement to have a written employment contract. It can be written or verbal. But regardless, there's going to be certain minimum standards that must be met, and these come primarily from Manitoba's Employment Standards Code. The code sets the minimum rights or the floor of rights that must be met in order to be a legal contract. It is not possible to contract out of these minimum rights of the Employment Standards Code. One common mistake that's made in employment is making the assumption that salaried employees don't get overtime. Most employees are entitled to be paid overtime anytime they work more than 8 hours in the day or 40 hours per week. This includes both full-time and part-time employees. Anytime that somebody works more than these hours, they're entitled to be paid 150% of their regular wage rate. There are some exemptions to overtime. For example, construction workers are exempt, and there may be averaging agreements in place which change the overtime requirements. But the code makes no distinction as to entitlements for overtime between hourly basis and those on a salary. One of the exemptions that is of importance is for those employees who perform management functions primarily. This has to be in actuality and not in title only. Another exemption is for an employee who has substantial control over their hours and whose regular wage is at least twice the Manitoba industrial average wage as seen on the screen. So bringing this all back to the very first mistake, unless an employee falls within one of the legal exemptions, a contract of employment that says compensation includes any and all hours worked is not going to be compliant with Manitoba's Employment Standards Code. Another common mistake that's made in employment contracts is putting in termination provisions, assuming that those termination provisions are going to be enforceable and valid when often they're not. Recall that the Employment Standards Code sets the minimum required rights. Any employment contract that purports to terminate with less than the required rights under the Employment Standards Code, shown on the screen here, is going to be invalid and unenforceable. For example, if an employee were to have a clause in their contract that allows termination without any pay or without any notice during, let's say, a 90-day probationary period, this would run contrary to the very minimum employment standards code amounts that we saw earlier, and it would therefore be invalid. Finally, another common mistake is when employment contracts don't have proper legal consideration. To be enforceable, a contract requires 3 ingredients: offer, acceptance, and consideration. Sometimes, however, employers will fail to provide proper consideration for an employment contract. This often occurs when an employee is already working for the employer and is given a new contract to sign that contains different terms and conditions. Consideration means something bargained for and received by a promisor from a promisee. Where an existing employee already has a contract and a new one is presented without anything more, this will usually fail for lack of consideration, and the contract would be unenforceable. Where a promotion or a new job opportunity or another advantage is given to the employee, that may be valid consideration. Otherwise, the new contract would not be enforceable. If you want to find out more information, please visit the Community Legal Education Association's website for more legal resources.